This is English Shorthand Dictation number 328 and the dictation speed is 120 words per minute. Ready? Start. This court has dealt with three different judicial pay commissions and has evolved certain principles which form the underpinning of judicial pay, pension, and allowances. The first principle is that a unified judiciary requires uniform designations and service conditions of judicial officers across the country. The second principle is that the independence of the judiciary requires that pay of judicial officers must be standalone and not compared to that of staff of the political executive or the legislature. The third principle is that the independence of the judiciary, which includes the district judiciary, is part of the basic structure of the constitution. The fourth principle is that the access to an independent judiciary enforces fundamental rights guaranteed under Part 3 of the Constitution. The fifth principle is that the essential function of all judicial officers in the district judiciary and judges of the High Court and this court is essentially the same. India has a unified judiciary under the scheme of the Constitution. A unified judiciary necessarily entails that the service conditions of judges of one state are equivalent to similar posts of judges of other states. The purpose of this constitutional scheme is to ensure that the judicial system is uniform, effective, and efficient in its functioning. Efficient functioning necessarily requires judges of caliber and capacity to be provided with the right incentives and promotion opportunities to maintain the high level of functioning of the judiciary. The judiciary in this country is a unified institution judicially, though not administratively. Hence, uniform designations and hierarchy with uniform service conditions are unavoidable. The further directions given, therefore, should not be looked upon as an encroachment on the powers of the executive and the legislature to determine the service conditions of the judiciary. They are directions to perform the long overdue obligatory duties. Separation of powers demands that the officers of the judiciary be treated separately and distinct from the staff of the legislative and executive wings. It must be remembered the judges are not employees of the state but are holders of public office who wield sovereign judicial power. In that sense, they are only comparable to members of the legislature and ministers in the executive. Therefore, parity cannot be claimed between staff of the legislative wing and executive wing with officers of the judicial wing. This court, in the case of All India Judges Association versus Union of India, explained the distinction and held that those who exercise the state power are the ministers, the legislators, and the judges, and not the members of their staff who implement or assist in implementing their decisions. Thus, there cannot be any objection that judicial officers receive pay which is not at par with executive staff. In this context, it may also be remembered that Article 50 of the Constitution directs the state to take steps to separate the judiciary from the executive. This distinction is also important because judicial independence from the executive and the legislature requires the judiciary to have a say in matters of their finances. This court has previously noted that theoretically allowing the executive to decide the pay of the judiciary may lead to unintended consequences. Therefore, to secure true independence of the judiciary, this court has recognized that the pay of judicial officers is separate and distinct from the pay of staff of other wings of the state. This is nothing but an articulation of the doctrine of inherent powers. This doctrine mandates that the judiciary must possess the inherent power to compel payment of those sums of money which are reasonable and necessary to carry out its mandated responsibilities and its powers and duties to administer justice. This doctrine is only the logical conclusion of separation of powers and ensures that the independence of the judiciary is secured. The submission of the states that there is a paucity of financial resources must be examined from this aspect of the matter. The states and the union have repeatedly stated that the burden on the financial resources of the states and the union due to the report of the second National Judicial Pay Commission is significant, and therefore the report cannot be implemented. Without the doctrine of inherent powers, any defunding of the judiciary cannot be repelled. Apart from this, judicial officers have been working without a pay revision for nearly 15 years. A pay revision has been recommended in accordance with the law laid down by this court, and a report submitted by a judicial pay commission after considering this very objection. This court has also examined this issue of paucity of financial resources on at least three occasions in these very proceedings. In the order dated 2802-2020, which took cognizance of the report of the Second National Judicial Pay Commission, this court stated that it hoped that the same objections which have been rejected by this court in the case of All India Judges Association versus Union of India will not be re-agitated. The court, in the aforesaid judgment, observed that compared to the other plan and non plan expenditures, the financial burden caused on account of the directions given therein are negligible. However, the states and the union raised this objection in their affidavits before this court. After going through the affidavits of the states and the union, this court on 27/07/2022 found that in contrast to the 7th Central Pay Commission, which was implemented from 01/01/2016, judicial officers have not received any similar benefit. Thus, the court held that there is a need to at least implement the revised pay structure immediately so as to alleviate the sufferings of the judicial officers. The court, after considering the objections of the union and the states, rejected the same and accepted the revision of pay structure as recommended by the Second National Judicial Pay Commission. Aggrieved by the acceptance of the report, the union filed a review petition before this court. This court, by order dated 05/04/2023, dismissed the review petitions and found that the financial implications cannot be considered as excessive in view of the information given by the Second National Judicial Pay Commission. Still, the states and the union have raised this objection after its express rejection twice over. The rejection of their objection is also reiterated. Judicial officers cannot be left in the lurch for prolonged periods of time without a revision of pay on an alleged paucity of financial resources.